Welcome to the Property Show. I'm Jayashree Kurup. I'm editor on MBTV. I have with me Anup Shah. If the project is not registered, can the consumer register his apartment if it's complete?
In my view, taking into consideration the present legal position, the apartment or the undivided share which is supposed to be registered along with the apartment can be registered with the registering authority if the promoter or the seller and the buyers want to register that apartment. There is no bar per se not to register it.
Can the occupancy certificate be given to a project that's not registered?
There are two aspects to it. One, if the project is an ongoing project or a project which is completed prior to RERA, then the occupancy certificate, if it is given, then the project becomes part of the pre-RERA project. Post RERA coming into picture, if it is an ongoing project, then an application needs to be made for the occupancy certificate. If the project is not registered with the RERA, but it's capable of being granted the occupancy certificate, then of course the occupancy certificate will be granted by the authority.
And if the authority grants an occupancy certificate, you can register your unit. After that, if there is any problem, if the project is not registered under RERA, can they still go to RERA for a defect liability or something like that?
Yes, taking into consideration some of the decisions which have come about from the RERA authorities in some of the states, it has been clarified to state that if any project which has been completed prior to RERA and if there is any defect liability which comes about within that 5-year period, then the 5-year period of the defect liability would be applicable to the projects which though the OC would have been granted before and the project may not have been registered. So we need to keep in mind that these are things which are in initial stages. The law will mature and within 2 years' time probably we'll have a firm law as to what exactly would happen to projects which are prior to RERA and post-RERA.
If there is an order in one state and I'm in another state, as a consumer, can I invoke that order and ask for compensation?
It's in every state has its own rules, and as we have in the high courts how the precedents are referred to, I have no doubt in my mind that if there is an order which has been passed in another state, you can refer that order in your state for redressing any of the complaints which you have, which are typical to the one which have already been passed, and the authority, in my view, should take into consideration the precedent that has been there, unless there is the factual difference between the two cases.
What about the builder-buyer agreements of the past, where the developer had some 5 rupees per square foot and things like that? He had to pay compensation, whereas the consumer had a 18% liability.
If the project is ongoing project or has been completed during the period where RERA came in, there are certain decisions by the authority, as in some of the other cases they have done, is that prior to the act coming to picture, the contractual obligation of both parties will apply. After the act coming to picture, both parties will be governed by the act, and the act always supersedes the contract. So as a result of which, to give you an example, is that, for example, my project is an ongoing project and not completed, and I come within the fold of the act prior to, and if there is a penalty which is to be applicable prior to the act, it will be going by way of the contract, but post the act it will go by the act. Hence, as a result of which, if there is a penalty to be given by the developer based on the act, then it will become the act which will become applicable. Similarly for the consumer too.
So some of the consumers who have come to us, they have said that there was a date of completion that was there in the builder-buyer agreement, and there's a date of completion that is registered under RERA. The RERA date is much further down than the builder-buyer agreement. Which one does he get compensated for?
The important aspect is there is no law on this aspect as far as the date change under RERA is concerned, and what would be the outcome of that date as compared to the contractual date. There could be contentions by the consumer to say that if you have given me that date, that means you yourself has probably mentioned and actually admitted the fact that the project is not getting completed on that date and gets completed later on. As a result of which, the compensation which probably gets paid to the consumer, as I earlier mentioned, could be based on the contract prior to the act coming in, and after that he could ask for the compensation based on the act.
So it is in
But these are still aspects which will require judicial pronouncement, judicial review, and we'll have to see how that works about.
Anup, the fourth thing is where the project has been delivered before RERA and there are deficiencies. Under what law is the consumer going to the RERA authority, because the developer tells him that the project is already complete. I got my OC before the RERA kicked in. So can the consumer go to the Consumer Redressal Forum or to RERA?
As far as the projects which get completed prior to the RERA coming into picture, that means the OC having come in, take into consideration some of the judgments, some of the views that have been taken. In my view, probably the consumer can take the help of the RERA Act in case of any deficiencies in the product or the project which has been there. Having said that, there is possibility that the developer would definitely contest the fact that you cannot apply the RERA. If that comes about, you already have a consumer forum before whom you can file a complaint for deficiency in services, which is being done prior to RERA in all cases. So you either have to then take a conscious call as to whether you want to go before RERA and seek your redressal and take it up to the Supreme Court in case it doesn't work for you, or then take a call to go to the NCLT.
Which one is faster, RERA or NCLT?
Presently with NCLT, as far as the today's setup is concerned, the consumer forum is more geared up to take up complaints as far as lots of RERAs in lots of states are concerned. But I think in the process of time, in a couple of years, RERA would be fully geared up in all the states, hopefully, as a result of which I think the redressal for a particular aspect of development, in my view, should be taken to RERA, because it will give you a specified answers with specific people, specialist people who are actually in real estate or development. As a result of the answers or your complaints can be answered much faster and much better.
The biggest problem with real estate is there's not enough finance in the market to complete a lot of projects. So will RERA enforcement be able to sort this imbroglio?
RERA will not probably sort out this problem, because RERA has nothing to do with the finances which are given by NBFCs or bank to promoters. It is basically the NCLT which probably will take into account the aspect of what has gone wrong, and it depends on creditors whether they move the NCLT or not. RERA probably is for the consumer, and now with the change in the amendment, as we discussed earlier, that the buyer, flat buyer, is a financial creditor. He has all the right, as soon as the financial creditor or a secured creditor takes a promoter or a company to NCLT, to be part of this.
Consumers are not financiers. They don't understand finance the way the finance sector can. What should a consumer be prepared with, and how does the consumer take it forward?
In my view, an individual consumer in a large project should not undertake this, legal proceeding. The consumers must get together and appoint a professional who would probably represent them, and which typically has happened even in the JP case, where the consumers have been represented by good lawyers. Those lawyers and accountants and professionals help the consumer in the NCLT proceeding to ensure that the projects get completed in a right fashion.
How does a consumer assess the legal professional?
As far as the consumer is concerned, I think he should make his little bit of inquiry in the legal profession and choose a person who has adequate knowledge and experience pertaining to real estate industry, and to some extent banking and company matters and company law matters, and the IBC now which has come in, and then he can make a choice of the lawyer he wants to choose.
Anup, when there's an unreasonable last request, the project is far from complete and the final request has come, what should the consumer do? How can RERA help here?
If there is an unreasonable demand which is not contractually payable, in my view, the consumer must ask the details of that amount. If the consumer finds that such amounts are not in terms of the contract, then the consumer has the right to deny such demands. And if there is an insistence on the demand, he has a right to complain before the adjudicating officer, who will then decide on the matter. As far as the demand raised by the promoter or a developer is legitimate and contractually paid.
The developer also has the right to cancel that allotment if the consumer doesn't pay the last installment. How does the consumer protect himself against that?
If there is a threat of such kind of cancellation, the consumer has a right to ensure that such cancellation doesn't happen by taking proceedings and asking for interim reliefs for the purpose of stay of any such cancellation of allotments or agreements.
From RERA?
It can be RERA, or it can be even before the court, if possible.
How does RERA help consumers on the one side and developers on the other? And how does RERA push the industry forward?
I've always been, once the RERA came, I have a strong belief, and I believe that this act will probably help both the consumer and the developer, because it brings in what is called the self-discipline, which most of the developers whom I know are actually following.
Which is why projects are getting completed.
And what would happen is also there are developers who probably self-discipline themselves and obviously get benefit of the RERA. There will be greater transparency for the consumer from the aspect of the project finances, the project status, stages, as a result of which the RERA will actually help both the consumer and the developer to ensure that the project gets completed in reasonably good amount of time as contractually stated in the contracts. And I think that as far as the developers are concerned, they will get their money also in time, because the RERA also ensures that the consumer complies with the contract and makes all his payments. And similarly, the consumer also will get the benefit of the fact that the developer will comply with the provisions of the contract under the Act.
Will the remaining projects also get registered under RERA? Will every consumer find that he is buying into a registered project, whether from the past, which is continuing, or in the future? Has RERA really helped? Please subscribe to Magic Bricks on YouTube and click the bell icon to get new videos.